Counsel, thank you very much for your presentations. The court is prepared to make its findings of fact and conclusions of law. In making its factual findings, the court has attempted to strike a balance between the sensitive nature of the information gleaned through the investigations conducted by the state and the defense on one hand, as seen through the prism of the Hertgen family, who have suffered the loss of one son at the hands of another son for whom they are also concerned, while on the other hand making the necessary factual findings to support the legal conclusions required by the court. The court's findings of fact are based on the state's investigation in this case, which are memorialized in state's exhibits 1 through 10 in Joint Exhibit J1, as well as the psychiatric forensic examinations conducted by Dr. Gianni Pirelli and Dr. Vivian Schneidman. Beginning with the years leading up to this tragic incident, during interviews conducted by detectives with the Mercer County Homicide Task Force, with the defendant's father, David Sr., as well as his older brother, David Jr., they shared that during the 5 years preceding this tragic episode, the defendant had been struggling with what they believed to be severe mental illness, including a history of delusional visions. Their views of defendant's psychiatric condition during that period of time have been confirmed by the psychological and psychiatric experts offered by the parties, with Dr. Pirelli noting both here in court today and in his report that the defendant was and continues to suffer from the most severe psychosis he has seen in his career, which spans 22 years and during which time he has conducted over 1,500 evaluations. Now turning to the day of the homicide, during David Jr.'s interview with detectives, he said that he had a conversation with the defendant earlier in the day on February 22nd, 2015. According to David, at that time, his brother appeared to be extremely distressed, despondent, and was experiencing terrifying visions. Wanting to help his brother, David picked him up at 4:30 p.m. from 621 Michelle Muse in Princeton, where the defendant lived with his parents, who were away that week, along with his younger brother, Joseph, who was at home. David took the defendant to the grocery store and then to David's residence, which was on Bayard Street in Princeton, where they remained until approximately 10 p.m. Around that time, David began driving his brother back home. Their arrival and subsequent events leading up to the homicide were captured by surveillance footage that detectives obtained from Palmer Square Management, the management company for the apartment complex. The footage came from 2 cameras. The first camera captured the entryway into the lobby of the apartment complex. The second camera was positioned in the courtyard and shows a partial view into the living room or dining room area of the defendant's residence at that time. At approximately 10:04 p.m., the window blinds to the apartment are open, and Joseph could be seen walking to and from the area of the living room to the area of the dining room and kitchen. Approximately 2.5 minutes later, at 10:06 and 40 seconds, the defendant, who was wearing a winter coat at the time, can be seen walking with his brother David from Paul Robeson Place and onto the courtyard at the apartment complex, where they eventually enter the lobby door. The two then proceed past the elevator lobby towards a stairwell that leads to the second floor residential hallway. Moments later, Joseph can be seen in the window walking from the area of the living room to the area of the kitchen, then back to the living room. Joseph is next seen at 10:09 p.m. walking across the window to the area of the living room, at which time a light is turned off, then back to the area of the kitchen, and back again to the area of the living room. At 10:10 p.m., David is seen on surveillance video walking out of the lobby doors to the apartment complex, through the courtyard into Paul Robeson Place, at which time he proceeds to his own home. According to David, prior to leaving, he had walked the defendant to the door of the family's residence, at which time he and the defendant entered the apartment. David had a brief conversation with Joseph before leaving the apartment and heading out of the building. At no time did David observe anyone else inside the apartment aside from his two brothers. Very shortly after leaving the residence, David sent a text message to Joseph informing him that their brother was struggling with his visions and to contact immediately if he needed any help. Joseph responded, quote, "will do," close quote, and thanked David for his assistance. At 10:20 p.m., surveillance video captured the defendant through the apartment window wearing a winter coat while he walked from the kitchen area to the living room. At 10:21 and 10 seconds, the defendant is seen walking in the living room and then out of camera view. 16 seconds later, at 10:21 and 26 seconds, both the defendant and Joseph can be seen on video appearing from the area of the living room and then engage in a physical struggle. During the struggle, the defendant can be seen striking Joseph numerous times with his fists and tackling him to the floor out of camera view. While Joseph is presumably on the floor, the defendant is seen continuing to strike in a downward motion numerous times. At 10:28 p.m., the defendant abruptly stands, walks to the window, and closes the blinds, obstructing the view into the apartment. At no time is anyone other than the defendant and Joseph seen on the surveillance video inside the apartment. At about the same time, David sends a text message to the defendant inviting his brother to join him on a hike the following day and advising him to, quote, "hang in there," close quote. But the defendant never responded to the text. At 11:16 p.m., dispatchers from the Princeton Township Police Department received a 911 emergency call from an individual later identified as the defendant, who advised that there was a fire and a dead body inside his residence located at 1621 Michelle Muse. During the call, the defendant identified the deceased individual as his brother, Joseph, and advised the dispatcher that Joseph had been lying lifeless on the floor of his residence for approximately 30 to 40 minutes. The dispatchers asked the defendant how Joseph was injured, to which he responded, quote, "I'm not going to go into any more details right now," close quote. The defendant again advised the dispatcher that there had been a fire inside the apartment and that he was alone in the residence with Joseph. When the dispatcher asked the defendant if any weapons were involved in the incident, he responded, quote, "like I said, I'm not going into any more details," close quote. Princeton patrol officers subsequently arrived at the apartment and were met at the front door by the defendant, who reiterated that there was a dead body in the apartment. Upon their arrival, officers saw that the defendant was utilizing his cellular telephone and still speaking with the 911 emergency operator. When the patrol officers entered the residence and they discovered Joseph's lifeless body on the dining room floor with a large pool of blood around his head and torso. Joseph appeared to have sustained severe blunt force trauma to the back of his head, as well as a laceration to his chest and abdomen. Officers also observed a golf club lying on the floor near Joseph's body with what appeared to be blood on the head of the club. In addition, officers discovered a deceased cat in the living room located on an ottoman. The cat appeared to have suffered blunt force injuries and was partially burned. Officers cleared the residence and found no other individuals inside. They subsequently secured the residence and notified members of the homicide task force pending application of a search warrant. As a result of the observations made inside the apartment, the responding officers conducted a pat frisk of the defendant for weapons, which was negative. However, while performing the pat frisk, officers observed abrasions and scratches on both of the defendant's hands. When the officers inquired as to how and when the defendant sustained the injuries, he said that he, quote, went into a fit of madness, maybe like 40 minutes ago, close quote. The defendant was thereafter detained and transported to Princeton Police Headquarters, where officers obtained buccal swabs from him. Members of the Homicide Task Force subsequently arrived at the apartment and initiated their investigation. After obtaining a search warrant for the apartment, the detectives, with the assistance of Princeton Police Department and members of the New Jersey State Police Crime Scene Unit, performed a full search of the apartment. During the search, officers located and seized numerous items of evidentiary value, including but not limited to a golf club with suspected bloodstains located on the dining room floor, another golf club with suspected bloodstains located on the living room floor, a large knife with suspected bloodstains located on Joseph's chest, a knife with suspected bloodstains and fur located on the living room ottoman near the deceased cat, and a cigarette lighter located on the living room ottoman next to the deceased cat. When the search of the apartment was complete, members of the Middlesex County Medical Examiner's Office took custody of Joseph so that an autopsy could be performed at a later date. The deceased cat was also transported to the New Jersey Animal Health Diagnostic Laboratory so that a necropsy could be performed at a later date. Additionally, officers took swabs of the suspected bloodstains located on the knife and golf clubs, as well as swabs of their respective handles. On February 25th, 2025, Middlesex County Deputy Medical Examiner Dr. Laura Toma conducted an autopsy of Joseph Hertgen. As part of the autopsy, she took fingernail clippings from him. Dr. Toma determined that Joseph suffered from multiple sharp and blunt force injuries to the head, chest, and torso. The doctor ultimately concluded that Joseph's cause of death was blunt and sharp force injuries to the head and chest, and that the manner of death was homicide. On February 26, 2025, veterinary pathologist Dr. Matthew Hertgen conducted a necropsy of the deceased cat. Dr. Kumar determined that the cat suffered from multiple sharp force trauma wounds to the thorax, as well as singed hair over the right side of the thorax and abdomen. The doctor ultimately concluded that the cause of death was due to blood loss caused by the sharp force trauma wounds to the thorax, complicated by pneumothorax caused by the penetrating chest wounds. On April 29, 2025, the New Jersey State Police Central Regional Serology Laboratory issued a report with its findings. The laboratory confirmed a presumptive positive test for blood on both of the golf clubs and the kitchen knife. On May 29, 2025, the New Jersey State Police Central Regional DNA Laboratory issued a report with its findings regarding the golf club located in the dining room. The laboratory confirmed that the blood on the head of the club was attributable to one individual, Joseph Hertgen. The laboratory also found the presence of 4 contributors, DNA on the handle of the club, concluding that there is moderate support, approximately 4.4 thousand times more likely to occur, that the defendant is one of the 4 contributors. Regarding the golf club located in the living room, the laboratory found that the blood on the head of the club is attributable to 2 individuals. The laboratory confirmed that the defendant is one contributor and found very strong support, approximately 41 billion times more likely that Joseph was the second contributor. Regarding the kitchen knife, the laboratory confirmed that the blood on the blade and the handle were both attributable to one individual, Joseph Hertgen. In connection with the defendant's insanity defense, the court has had the benefit of the forensics, psychology, and psychiatric reports written on his behalf by Dr. Pirelli, as well as his testimony. The state has also provided a report from Dr. Vivian Schneidman. Both doctors are board certified in their respective fields, and the court finds that they are experts in their fields based upon their substantial education, training, and experience. Both doctors concluded that the defendant was legally insane at the time he committed the offenses contained in the indictment. In reaching their conclusions, the doctors conducted an extensive review of materials relating to this case and the defendant's background. The review included all of the criminal discovery, clinical interviews of the defendant and his family members, the defendant's drawings and writings, as well as his medical psychiatric records from Life Back Outpatient Psychiatry from October of 2021, Princeton House Behavioral Health, also from October 2021, Sutter Health at Palo Alto Medical Foundation from June to August 23rd, 2023, from Hampton Behavioral Health Center from October 3rd, 2023 to October 11th, 2023, from Charlie Health from October 12th, 2023 to January 4th, 2024, from Telepsychiatric Medical Management from July 29th, 2023 to September 19th, 2024, from Anne Klein Forensic Center, where the defendant was sent after trying to take his own life shortly after he was detained on the instant charges beginning on March 13th, 2025, and from the Mercer County Correctional Center from July of 2025. The court incorporates the doctor's reports and related findings herein by reference. With those findings of fact in mind, the court now turns to its conclusions of law. The defendant is charged in the indictment with first-degree purposeful or knowing murder of Joseph Hertgen. The indictment also charges the defendant with 2 counts of fourth-degree unlawful possession of a weapon, that is a knife and a golf club, along with 2 counts of third-degree possession of those weapons for an unlawful purpose, that is to use it unlawfully against the person of Joseph Hertgen. The final count of the indictment charges the defendant with third-degree animal cruelty. The state has the burden of proving each of those charges beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves the fact finder firmly convinced of the defendant's guilt. On the other hand, a reasonable doubt is an honest and reasonable uncertainty about the guilt of the defendant after giving full and impartial consideration to all of the evidence, which may arise from the evidence itself or a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. In order for the court to find the defendant guilty of purposeful and knowing murder, the state is required to prove 2 elements beyond a reasonable doubt. The first element the state must prove is that the defendant caused Joseph Hertgen's death or serious bodily injury that resulted in his death. The court finds that the state has met its burden in connection with the first element. The evidence establishes that the defendant was alone with Joseph at the time of his death. In that regard, the defendant's parents were away during the week that the murder took place. And when David returned to the apartment at 621 Michelle Muse with the defendant, only Joseph was inside. Shortly thereafter, surveillance video shows David exiting the building by himself, leaving only the defendant and Joseph inside the apartment. The fact that the 2 of them remained alone is further corroborated by the courtyard surveillance camera, which shows that no one other than Joseph and the defendant were inside the apartment at around the time of the homicide. The state has also established beyond a reasonable doubt that it was the defendant who took Joseph's life. Surveillance video from the courtyard camera shows the defendant in a violent struggle with Joseph, during which time he throws his brother to the ground and appears to be repeatedly striking him from above. The defendant subsequently calls 911 to report Joseph's death at approximately 11:16 p.m., at which time he informs the dispatcher that his brother has been lying lifeless in the apartment for about 30 to 40 minutes. That 30 to 40 minute time frame roughly corresponds with the time that the defendant is captured on video engaging in the previously mentioned struggle with his brother. And when the police respond, they found the defendant with cuts and abrasions on his hands, indicative of that earlier struggle. They also found physical evidence of the homicide consisting of Joseph's injuries, the implements of his death, which were found nearby, including a large knife located on his chest and a bloody golf club nearby. The other statements that defendant made to the 911 dispatcher and responding officers, along with serology and DNA evidence, further supports a finding that the defendant took his brother's life with a knife and a golf club. The second element that the state must prove beyond a reasonable doubt is that the defendant acted purposefully or knowingly in causing Joseph's death or serious bodily injury resulting in his death. A person acts purposely when it is the person's conscious object to cause death or serious bodily injury resulting in death. A person acts knowingly when the person is aware that it is practically certain that his conduct will cause death or serious bodily injury resulting in death. Purpose and knowledge are conditions of the mind which cannot be seen and can only be determined by inferences from conduct, words, or acts. Thus, a finder of fact can find that proof of purpose or knowledge has been furnished beyond a reasonable doubt by inferences which may arise from the nature of the acts and the surrounding circumstances. For example, a homicide or killing with a deadly weapon would permit the finder of fact to draw an inference that the defendant's purpose was to take life or cause serious bodily injury resulting in death to Joseph. Here, as demonstrated by the autopsy report, the defendant used a knife and golf club, both of which constitute deadly weapons, to take his brother's life. In addition, the number and nature of the wounds inflicted are also circumstances to be considered in deciding whether the defendant acted with the requisite purpose or knowledge. According to the autopsy report, the defendant inflicted 7 lacerations to the right side of Joseph's head, a depressed fracture of the right temporal and parietal bones, and 7 stab wounds to his chest, at least 2 inches deep, causing injury to his pericardium, right ventricle, and pulmonary artery. In sum, the court is satisfied, based upon the review of the exhibits admitted at trial, that all of the elements of the offense of purposeful or knowing murder as set forth in count 1 of the indictment as they pertain to the death of Joseph Hertgen at defendant's hands have been proven beyond a reasonable doubt. As previously noted, the defendant is charged in 2 counts of the indictment with 4th-degree unlawful possession of a weapon. In order to convict the defendant of these crimes, the state must prove 3 elements beyond a reasonable doubt. First, the state must prove beyond a reasonable doubt the knife found on Joseph's chest and the golf club found nearby were weapons. A weapon is defined as anything readily capable of lethal use, of inflicting serious bodily injury. The court is satisfied that both the knife and the golf club meet that definition. The second element the state must prove beyond a reasonable doubt is that the weapon was knowingly possessed by the defendant at the time and place alleged. A person is in actual possession of a particular article or thing when he knows what it is. That is, he has knowledge of its character and knowingly has it on his person at a given time. A person who, with knowledge of its character, knowingly has direct physical control over a thing at a given time is in actual possession of it. The court is satisfied that the state has carried its burden as to this element for the same reasons explained in connection with the purposeful or knowing murder count of the indictment. The third element that the state must prove is that the defendant's possession of the weapon was under circumstances not manifestly appropriate for a lawful use. The court has no difficulty in finding that this element has been met given the manner in which the knife and golf club were used by the defendant. In sum, the court is satisfied, based upon a review of the evidence admitted at trial, that all of the elements of the offenses of unlawful possession of a weapon set forth in counts 3 and 5 of the indictment have been proven beyond a reasonable doubt. As previously noted, the defendant is also charged with 2 counts of the indictment with third-degree possession of a weapon for an unlawful purpose. In order to convict the defendant of these crimes, the state must prove the following 4 elements beyond a reasonable doubt. First, that the knife and golf club were weapons. Second, that the defendant possessed the knife and the golf club. Third, that the defendant possessed the knife and golf club with the purpose to use it against his brother. And fourth, that the defendant's purpose was to use the weapons unlawfully. Here, the court incorporates its previous findings with respect to the elements of all the previous charges. As a result, the court is satisfied, based upon a review of the exhibits admitted at trial, that all of the elements of the offense of possession of a weapon for an unlawful purpose, as set forth in counts 2 and 4 of the indictment, have been proven beyond a reasonable doubt. Finally, as previously noted, the defendant is also charged in the final count of the indictment with third-degree animal cruelty. In order to convict the defendant of this crime, the state must prove 3 elements beyond a reasonable doubt. First, that the defendant mutilated a living creature. This element was satisfied by the results of the necropsy performed by Dr. Kuhar, which established that the cat found on the ottoman was mutilated insofar as it suffered multiple sharp force trauma wounds to the thorax and singed hair over the right side of the thorax and abdomen at the hands of the defendant. The second element the state must prove is that the cat died as a result of the mutilation. Again, the necropsy report satisfies that element, as Dr. Kuhar concluded that the cause of death was due to blood loss caused by the sharp force trauma wounds to the thorax, complicated by a collapsed lung caused by penetrating chest wounds. The third element the state must prove is that the defendant acted purposefully or knowingly. I've already defined those terms. The court is satisfied that, based upon the nature of the stab wounds, they were caused by a deadly weapon, as well as the fact that there were 12 stab wounds to the cat. The state has proven that the defendant has acted purposefully or knowingly. In sum, the court is satisfied, based upon a review of the exhibits admitted at trial, that all of the elements of the offense of animal cruelty set forth in count 6 of the indictment have been proven beyond a reasonable doubt. Given the fact that the state has proven beyond a reasonable doubt each essential element of the offenses contained in the indictment, the court must next consider whether the defendant is not guilty based upon the defense of insanity. To establish insanity as a defense to a criminal charge, in this case, the defendant must prove by a preponderance of the evidence, which is defined as the greater weight of the credible evidence in this case, that the defendant was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or if the defendant did know it, that he did not know that what he was doing was wrong. If so, the defendant was then legally insane and therefore not criminally responsible for his conduct. In order to make that determination, the finder of fact should consider all of the relevant and material evidence having a bearing on the defendant's mental condition, including his conduct at the time of the alleged act, his conduct since, any mental health history, and any lay and medical testimony in the record. By way of background, both of the doctors in this case find that the defendant suffered from and continues to suffer from schizophrenia and was actively psychotic at the time he committed the offenses contained in the indictment. They explain that while memory can remain intact, and a person suffering from the disease can speak logically and perform organized acts, what becomes impaired is the ability to judge what is real and what is not. With respect to the defendant, his conduct at the time of the offenses was detached from reality. According to the doctors, the defendant has a documented history of a progressive psychotic illness beginning in at least 2021 and possibly and most likely earlier. Over time, he developed persistent religious and cosmological delusions, visual, perceptual disturbances, fixed beliefs about having two souls, and a declining ability to distinguish internal symbolic experiences from external reality. Although his diagnosis was labeled inconsistently over time, the longitudinal record reflects persistent psychosis independent of mood episodes, structured delusional thinking, and impaired reality testing consistent with schizophrenia. A core feature of that disease is the presence of fixed delusions. These are beliefs held with extraordinary conviction, resistant to evidence and reason. In some cases, individuals experience a sense that thoughts, meanings, or actions are directed by forces outside the ordinary self. Neutral events may acquire overwhelming personal significance. And in the defendant's case, he believed and continues to believe that he possesses two souls, that those souls were turning dark, and that he was somehow connected to both Christ and the Antichrist. He believed that if he did not act, spiritual catastrophe would follow. When he read the works of Carl Jung, he interpreted Jung's writing as a literal directive that he must commit an act of evil in order to save his soul. According to the doctors, while the defendant's rational mind understands that killing is wrong, at the time of the offense, his delusional belief system had replaced ordinary reality with a false cosmology. He didn't experience the act as murder. He experienced it as spiritually necessary to prevent catastrophic consequences. When a person genuinely believes he is preventing eternal damnation or cosmic destruction, the ordinary moral meaning of wrong is no longer operating in the same way. The illness distorts the person's capacity to appreciate the true nature and wrongfulness of the act. In summary, under New Jersey law, a person is not criminally responsible if, at the time of the conduct, as a result of mental disease or defect, he lacked substantial capacity either to appreciate the nature and quality of the act or to appreciate that the act was wrong. According to the experts here, from both sides in this matter, the defendant suffers from schizophrenia, which constitutes a severe mental illness. At the time of the offense, his thinking was governed by a fixed and systematic delusional belief that he was required to commit an act of evil to prevent spiritual catastrophe and save his soul. With respect to the nature and quality prong of the analysis, the defendant did not experience his actions as ordinary homicide. Within his psychotic framework, he believed that he was engaged in a spiritually necessary act to prevent eternal damnation. Although he physically understood that he was inflicting injury, the meaning of the act was fundamentally altered by delusion. The act was not experienced as murder, it was experienced as a salvific or spiritually compelled act. His mental disease therefore distorted his appreciation of the true nature and quality of what he was doing. With respect to the wrongfulness prong of the analysis, although the defendant retained intellectual awareness that killing is illegal, his psychotic illness impaired his capacity to appreciate its moral wrongfulness. In his delusional state, the act was not wrong in the ordinary moral sense, it was required. The delusional belief system overrode ordinary moral reasoning. As a result of mental disease, he lacked substantial capacity to appreciate the wrongfulness of his conduct at the time of the offenses. Based upon this court's review of all exhibits introduced at trial, as well as the testimony elicited today, the defense has met its burden of proving by a preponderance of the evidence that the defendant meets the statutory criteria for legal insanity under New Jersey statute annotated 2C:4-1. Consequently, the court finds that the defendant is not criminally responsible for his actions because, at the time of the relevant conduct, he was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was committing, or if he did know it, that he did not know what he was doing was wrong. Counsel, giving the findings by both of the doctors, do the parties agree that Mr. Hertgen cannot be released to the community without supervision or conditions without posing a danger to the community or to himself?
Yes, Your Honor.
Yes, Your Honor.
Therefore, the court will be required to order his commitment to the Commissioner of the Department of Health pursuant to New Jersey Statute 2C:4 20-8, pending further evaluation regarding whether or not he should be released to the community, and if so, under what conditions. Do the parties also agree that the maximum term of the sentence in this matter would have been life in prison?
Yes, Your Honor.
Yes, Your Honor.
I'm going to order that a report be provided to the court within 30 days. And I'm going to schedule a review hearing for, if the parties are available, April 24th at 2:30.
I'm out of town that week, so.
It's okay. Does May 1st at 2:30 work for everyone?
It's fine for me, Your Honor.
I need to check my calendar.
Take your time.
So it's Friday at 2:30?
Yes, May the 1st.
That's fine.
What I'm going to do, counsel, is draft a proposed form of order. Hopefully I'll be able to send it out to both of you sometime today. If you have any proposed edits, please feel free to just reply by email, and we'll come to a conclusion on the final form of order. Anything further from the state?
Nothing from the State Judge, thank you.
Mr. Ansel, anything further?
No, thank you, Your Honor.
Okay. To the family, you have my deepest sympathies. You have been and will continue to be in my prayers. Mr. Hertgen, we're going to see you back here on May 1st at 2:30, okay? Thank you very much, everyone. The court's in recess.
Thank you, Your Honor.
Thank you, Your Honor.